Hi, my name is Soraya and I am Reprieve's Middle East and North Africa Coordinator. And today I'd like to talk to you a bit about the strategies Reprieve uses to assist European nationals facing the death penalty around the world. I'm really sorry I couldn't be there today, but I hope to hear from you about how Reprieve can potentially help you and how you might also be able to help us. Our motto is we investigate, we litigate, and we educate. And I hope that through the strategies I discussed, you can get a sense of how our motto really does come into play. Once we have identified a case, we work closely with the relevant governments, with the prisoner's local lawyers and NGOs in order to ensure that the prisoner has as much support as possible. And this can have important ramifications for assisting and upholding the defendant's right to a fair trial and generally upholding the rights of the accused. The ultimate goal of our work is to ensure that the fields of the death penalty are narrowed. We also aim to work with the EU in terms of identifying cases where EU minimum standards on the death penalty have been violated. So we are particularly interested in cases where juveniles and mentally ill or those with intellectual disabilities have been sentenced to death. So the first strategy that we employ is investigation work. Mitigation investigation is quite an important part of this. So what we can do is facilitate medical experts or forensic experts to review evidence or submit evidence. Another way that we can support mitigating evidence submissions is by reviewing medical records or school records that might indicate mental illness or intellectual disability, which will then help in litigation. In some cases, we do victim outreach, where in cases of murder in particular, the victim's forgiveness will be essential in ensuring that the defendant does not receive the death sentence. And finally, if there are foreign ties, we can establish those through family history research and then ensure that the nationality is recognised by the European government, which will in turn often assist in filing submissions to the court on behalf of their foreign national. And that leads me on to the legal strategies that we employ. We can advise local lawyers on international law arguments that they can raise at trial. This can include submissions from international bodies and European governments, but we can also file complaints on behalf of people where rights of the accused have been violated by the state. So, for example, in cases where torture has been used to extract a confession, not only can submissions to relevant UN special rapporteurs be submitted, we can also assist local lawyers in getting evidence to support the defence at trial. We also can litigate in Europe because Europe is a good forum to discuss human rights arguments around the death penalty and to get judgments in our favour, which can later be used to apply pressure on governments seeking the death penalty. And this has been particularly effective in the Stop the Lethal Injection project, where we successfully obtained an export ban of execution drugs from the UK to the US. The diplomatic strategies that we use often involve engaging European governments who have nationals facing the death penalty abroad to intervene in these cases because they legitimately can. This can be, for example, in requesting that they provide consular assistance. On a very basic level, a prison visit can do amazing things for the morale of a prisoner, but it can also serve as a venue for the prisoner to raise issues such as violations of due process, torture, denial of legal counsel, and things like that, which can later be used to make representations to the government. Particularly in relation to torture, if a prisoner has raised these allegations, the European government will often support their national through raising these complaints with the local authorities. And if the access has come early enough, they might even be able to make notes in official consular documents, which can then also be obtained and used at trial to support that defence. But diplomatic intervention is very effective only at the beginning. It can be helpful throughout, but we find that it's best from the moment the person is arrested. Now, the issue with this is really in the Middle East and North Africa, and in Iran in particular, the governments do not recognise the person's second nationality. So an issue really does arise with dual nationals. I have to say we're working on this issue and we would love to hear from people who are representing dual nationals and the obstacles they face so that we can try and help you overcome them. Media can sometimes be very helpful in cases. Once we have decided that media can be pursued and should be pursued, the ultimate goal of it is to raise public awareness about the case, particularly in non-lethal offences, and also where there have been gross violations of due process. And this also helps reinforce arguments that can be raised in different avenues. So, for example, if you've gone to the United Nations, this can be a very important press hook. And again, this can apply pressure on the government assisting the national facing the death penalty, but in turn apply pressure on the government seeking the death penalty in itself. So I would like to talk to you about one of our cases that we worked on very recently, and that is of Hasnan Ali in the United Arab Emirates. Hasnan is a 32-year-old British national who was badly tortured by police in Dubai when he was arrested in May 2013. In April, he was acquitted of all offences, but he was originally facing a death sentence for drugs charges. We met with Mr. Ali in jail and we gathered information on the torture that he was subjected to, which was very horrific. It included beatings, threats of sexual assault, sleep deprivation, and threats with weapons. At the end of 4 days of torture, he was forced to sign a confession in Arabic, a language that he does not read, write, or understand. Through the gathering of this evidence supporting the claim of torture, we were able to help his legal team raise that defence at trial. We gathered some witness statements from prisoners who saw the extensive injuries on Mr. Ali, and they then testified at trial. We also got an independent medical review of a report conducted by the public prosecution into the lack of injuries actually that were sustained. And this was also very helpful for their lawyers to uphold the defence of torture. At the same time, we worked with the British government to apply pressure on the UAE authorities to comply with international law. So I hope that this case has shown that the investigative work and the litigation work that we do can really have positive effects on cases. But I say that because we know that we were able to intervene immediately. We found out about his arrest quite soon after it happened. So I would say that, these things can really help as soon as you really can intervene in the case. At the beginning, I said that our motto was we investigate, we litigate, and we educate. And what I mean by educate is that we want to learn from each other about the successful tools that everyone uses on the path towards abolition. And we are hoping to learn from everyone, particularly in Iran, about the landscape of the use of death penalty and potentially where we might be able to help you. We have been very successful in representing foreign nationals and European nationals. So I ask, do you know a European national or a foreign national or a dual national facing the death penalty in Iran? Because if you do, we might be able to help. Alternatively, are you representing or do you know someone representing someone sentenced to death for a non-lethal offence who is mentally ill or intellectually disabled? We are always happy to promote best practices and share information. So I hope that you will get in contact with us so that we can help towards a moratorium in Iran and eventually abolition. Thank you.